Day, so we got a busy agenda and a lot of last minute changes. I want to thank Kylan for helping me. We were making changes late into the night, actually, and I want to thank Sarah also and Ledge Council for working overtime to get these bills ready that we're going to hear today. I'd like to ask our President Pro Tem, if he would, to open us with a word of prayer.
Happy to, Mr. Chairman. Thank you. Pray with me, please. Heavenly Father, thank you for giving us another day. Thank you for all the blessings. Thank you for giving us the opportunity to come here and represent the good folks of Georgia. Please continue to be with us and give us wisdom and judgment and guidance, and please forgive us of our sins along the way. In Christ's name, amen.
All right, I'll call the committee meeting to order, and first on our agenda is Chairman Kirkpatrick with Senate Bill 20. This is a bill that was in subcommittee and was reported favorably out of subcommittee. There's since been some changes. We're not going to have any testimony on the bill today, but we do want the chairman to explain the new version and point out the changes, and then we'll see what the will of the committee is. All right, the floor is yours. What mic are you?
11.
Thank you.
Is it okay with you if I stay here?
Yes, ma'am.
Okay. Thank you. You have a sub in your folder that is LC 52092S. Is that correct, Mr. Chair?
LC 520292S.
That's what I meant.
Yes, ma'am.
Okay. All right. This bill was originally designed to do two things. First, to give our insurance commissioner the ability to assess health insurance network adequacy and the tools to enforce their findings. And secondly, to give consumers the ability to access the care they need when a network does not have the options that they need. There are new federal standards that define appropriate time and distance that took effect in January of this year, and they're in your folders. And you can see that they're very specific, and they're broken down by urban, rural, suburban, et cetera, by specialty. We currently don't have the ability to address this at the state level. This bill gives our insurance commissioner the ability to assess network adequacy in different parts of the state and to work with insurers when they identify problems. It also allows the commissioner to get more information and to enforce the standards. This bill is complex, and it's been through many changes as I worked with groups including advocates, hospitals, the commissioner's office, and the insurance industry. Network adequacy legislation was a recommendation of the Behavioral Health Commission as it relates to mental health and substance abuse. The chair had some concerns about the previous version of the bill, and the result is what you have today. I'll walk briefly through the bill, and I'm sure Chairman Walker will have some comments after that. This bill only relates to insurance plans under the jurisdiction of the insurance commissioner. Section 1 names the Catch Act. Section 2, line 19 through 21 exempts HMOs, and it tightens up the definition of an HMO. And lines 21 through 31 lay out the requirements for insurers regarding adequate networks, including both physical and mental health. Lines 32 through 39 give the criteria that the commissioner shall use and refers to the federal standards. And line 40 through 42 state that pre-authorization shall not be denied because a referral to an in-network provider was made by an out-of-network provider. Lines 44 through 55 address parameters around telehealth and clarifies existing law. Lines 57 through, the line numbers may be slightly different because this sub is hot off the press and is just a little bit different than what we were working with last night. But the next section talks about giving the commissioner, in line 58, the ability to promulgate rules for this code section. And then after that, the line 60 to 63 require insurers to monitor the ability of its participating providers to furnish all the contracted benefits. 64 through 66 require an annual report by insurers to the commissioner. And then the rest of the bill gives the commissioner authorization to do audits, data calls, market reviews, or whatever is necessary to determine compliance, to set out remedies with the insurance industry, and to assess penalties. So I'll briefly go through the changes from the previous sub. The bill expands the HMO exemption and clears up the definition of an HMO. It removes the process for covered persons to receive coverage for services from non-participating providers, removes the requirement to notify the commissioner of network changes. This is covered elsewhere in the code. And it requires the commissioner to consider factors like availability of providers when making decisions. So before I take questions, I will say that this bill takes the important step of giving our insurance commissioner the tools needed to assess network adequacy and to make decisions about compliance. This will be very helpful, especially in our underserved areas, and I appreciate the chairman working with me on this bill. And he may have some comments about why we made the changes.
Sure, and Chairman Kirkpatrick, thank you for your hard work on this, and I'm very comfortable with the version we have here. I was a little, as you all know, that most people in Georgia that have health insurance are covered by their employer's plan, a group health plan through their employer. The employer is the one that chooses the plan and chooses the network, not the employee. And the one of the versions, the original version, had a requirement or a ability for any disgruntled member, an employee, regardless of whatever reason, if they wanted to go out of network, they basically could complain to the commissioner, which would start this whole process of an investigation and a hearing, and I just felt like that was pretty onerous, and basically that's the crux of the changes that were made. The others were pretty minor, but I do think this is a very good step forward for the Georgia consumer, and to make sure that they're buying a product that does have adequate network and getting value for what what's being paid for. I'll open the floor to the committee for any questions. Again, we've worked on this for several weeks, and we're not going to have any public testimony or questions from the audience. Yes, sir.
Thank you, Chair. I appreciate your hard work on this legislation. A couple of questions. I'm looking on the summary. At the top it says requires insurance, including those that provide mental health and substance abuse disorder coverage, to contract with providers. But what we're not doing is we're not requiring insurance companies that don't today provide mental health or substance abuse to go out and find individuals that do provide those services, right?
That's correct.
Okay. So has it been a problem in the past that we had insurers that did provide those two benefits, yet they did not have a contract with someone who could provide those in-network?
Anecdotally, Mr. Chair, yes. But we passed legislation on that last year
Right.
that you probably remember in
1013.
1013
Yes, ma'am.
about mental health parity. And so that covers a lot of the concerns in this area. But we really don't know because we haven't given our commissioner the authority to assess those things.
Okay, thank you.
Any other questions? Any other questions? What's your? All right, go ahead.
Good morning. Good morning. Thank you, Mr. Chairman. Is Kaiser excluded from these provisions?
Yes.
Okay. Is there going to be some type of note on the state marketplace that specifically states that Kaiser is excluded from these provisions so that people are aware?
In fact, the original version excluded the closed panel HMOs like Kaiser. This version excludes all the HMOs.
Okay, and people will know that when they go to the state marketplace website, I guess.
I
is my
hope so,
concern.
but, purchasing insurance is frequently very complicated, and a lot of times people don't know all the details of what they're purchasing. So we're going to have to leave that to the commissioner to assess if we have problems with that.
Okay, thank you.
Senator Merritt, I'm told, and I don't want to misspeak, because my understanding is that HMOs are required to also offer a point of service plan in parts of the state that they don't have adequate network for the HMO. So there's a separate, apparently there's some separate rules and regs or separate code section on HMOs. But again, this to me does not impact, you mentioned the marketplace. So this isn't an ACA, this impacts group health plans the way I see it. So the employers are buying the plan. The employers should be educated enough, maybe they're not, but to look at the network, and the employers are making the decision, not the employees. So, but this does help that situation, but it really doesn't address the ACA plans through the marketplace, in my opinion.
Okay.
Any other questions? All right, thank you. All right, what's the will of the committee?
Do pass, Mr. Chairman?
All right, got a motion do pass and a second from Senator Cowser. Any further discussion? All those in favor of a do pass recommendation on LC 520292S, please raise your hand. All right, any opposed? That carried unanimously. Thank you, Senator. All right, our next bill that we're going to look at, and this is one we had a hearing on, I think, last week. Senator Dolezal, Senate Bill 186, LC 442196, Georgia Landowners Protection Act. Senator Dolezal, if you'll give us a summary refresh us on what the bill does, and we'll see if we have any questions.
Thank you, Mr. Chairman. I'll keep this brief. As you mentioned, we did hear this last week. I opened my comments last week the same way I'll open them this morning. We all, I think Republican and Democrat, campaigned in our districts last year talking about the reality that Georgia was the #1 state to do business. But I don't think that we talked about the other reality, which was that last year, for the first time ever, Georgia overtook California as the #1 judicial hellhole in America. And I asked a rhetorical question that none of us know the answer to, but that is, how long can those two things coexist? How long until business begins to take a hit because of our judicial climate in this state? And so I bring to you Senate Bill 186, which simply limits the liability of landowners as it relates to the actions, willful, wanton, and intentional tortious conduct by any third party on their property. We mentioned a number of cases that we've seen in Georgia in our testimony, and we are not trying to completely exclude landowners from liability. In fact, this bill does not do that, but this bill does put reasonable guardrails around the limits of liability as it relates to a landowner for things that happen on their property that they are not aware of and cannot reasonably or should not reasonably be held responsible for.
All right, any questions for the author? No questions. What's the will of the committee? So we have a motion to pass from Senator Harbins and a second from Senator Cowser. Any further discussion? All right, all in favor of do pass on Senate Bill 186, raise your hand. 1, 2, 3, 4, 5. Opposed, like sign. 2 opposed. All right, it passed with a majority vote.
Thank you, Mr. Chairman.
To you. Thank you very much. All right. Do you want to present from there? You can, or if you want to.
I'll go back.
Okay. So, all right, next on the agenda is a bill we have not heard this year. It's Senate Bill 225, LC 520721.
Thank you, Mr. Chairman.
Mr. Vice Chair, the floor is yours.
appreciate it. The floor is mine. That's good. I appreciate it. Thank you for allowing me to present this again. This bill really started out in 2016 when the state of Florida and their attorney general found the insurance agents or the insurance companies were knowing people were dead, but had no way in which to find those people who those policies were in place with. The settlement that the companies knew people were dead, and they would cut off their income, but yet they did not give notification of the death that they had a life insurance policy on them. So what happened is this: the National Association of Insurance Commissioners came out with something called Policy Locator. If you go to our state website for an insurance commissioner and most of the departments of insurance, you will find that there's a Policy Locator that is the National Association of Insurance Commissioners. But there's a problem, and that problem is this: insurance companies are regulated by each state. They are not regulated at the national level, but the insurance commissioners at the national level saw the need to find policies. Briefly, if you have a life insurance policy, you have three entities that are represented: the owner of the policy, the insured, and the beneficiary. The contract is with the owner, or the insured, or with the owner, not the insured. So I could have a policy on my wife, I could own the policy, my kids could be the beneficiary, so there could be three parties that are involved. Once the insured is dead, the question is, how do the beneficiaries know that? I have a case that we dealt with last year. Her grandfather bought a policy on her mother. Her grandfather had been dead for 14 years. Going through his stuff, found a policy on her mother that they didn't know existed. And the daughter said, wow, I got this on my mom, and it was worth about $6,000 or $7,000. So finding the policies is a real issue that's there. I went through last night and went to the policy locator of the National Association. The National Association has a Q&A, but listen to this. Question number 9 says, what life insurance and annuity companies are participating in the plan to find a policy? And here's what it says: insurance companies are participating on a voluntary basis. Now, I will tell you, most of the major companies have worked very hard and are doing that, but there are companies that have no requirement to check the database. And if you have a father, a mother that dies, and you say, do they have a policy, you can put that out on the national website, but there's no mandate for the companies in Georgia to search that database. And it says this: the insurance companies are participating on a voluntary basis. Any insurance company that's not currently participating may become a participating company by contacting the National Association of Insurance Commissioners. So what this bill simply does is this. If you look at it, it says, an insurer shall conduct a search of the National Association of Insurance Commissioners policy locator at least quarterly, and shall report to the commissioner annually the results of such search and additional information that the commissioner deems necessary. Such reports shall be submitted by the deadlines and in a manner formatted as prescribed by the commissioner. What this bill simply does, it says to the insurance companies that do business in the state of Georgia, they will quarterly look at the national policy locator. They will report that annually to the commissioner for what they're finding. And what I see is this: there are many policies, a lot of smaller policies that are hidden. Here's the other part. If they cannot find, if they know you're dead, and here's how they know you're dead: they look at the Social Security death benefit list, but they still do not know who the beneficiary is. And many of our older policies did not give an address, it just gave a name, and that's all there was. So it's very hard to find. But what this does, I believe, for the citizens of Georgia, it gives them a way in which they can find a policy potentially. And so it's a very simple bill. It puts the commissioner over that, and it makes the insurance companies that do business in the state of Georgia responsible to check that database at least quarterly.
Thank you,
Okay.
Senator.
Questions?
We do have some questions. We've also got somebody signed up to speak to the bill.
Okay.
So I'll let Senator Harbinson, 10.
Number 10, yes, sir. Mr. Chairman, isn't that true that you brought this forth, last couple of sessions?
At least, yes, sir.
At least, and And can you tell me, what is the major barrier? I mean, is it the length of time people are opposed to having the searches done, or just, or the act itself, just don't want it done? What's your
I don't see
reasoning
the hidden enemies of what's going on. This is transparency at its finest, in my opinion. And I believe this is, is there a cost involved? Yeah, somebody's got to do it.
Yeah.
But here's the issue. There are people who have money that's sitting there.
Yeah.
And if it is not received by the beneficiary, it goes to the state of Georgia in unclaimed, in an unclaimed issue. So I believe it belongs to the people who paid for it is where it should go. And I don't understand it myself, why this has not gone forth.
Okay, all right. Thank you, sir.
Thank you.
Yes, sir. All right, we have a question from Senator Randy Robertson.
Mr. Chairman, your legislation, you said the insurance companies that operate in Georgia. So is this any insurance company that does business in Georgia? They don't necessarily have to be licensed in Georgia, right?
It would be that those who are licensed in Georgia and under the purview of the commissioner would be responsible. If you bought a policy in New York that, let's say, was not a company that's in Georgia, this would not apply to them. But what applies is any company that is licensed in Georgia should be under that purview of the commissioner.
That has a business license in Georgia may not necessarily. I have a large insurance company in my district that I think their certificate is in Nebraska.
Right.
Right. But they have a business license here in Georgia and operate. So it would be any business that operates within the state of Georgia if the policy was
Correct.
was purchased here.
Correct.
Okay, thank you.
All right, any other questions from the committee? Just as a side note, we had a bill in Senate Agriculture and Consumer Affairs yesterday dealing with unclaimed property. And it's a staggering figure of how much dollar value of unclaimed property the state holds. Senator Anderson, whose bill was that? Do you remember? It was Chairman Goodman's bill, dealing with unclaimed property. Anyway, all right, thank you, I digress. All right, thank you, Senator.
Okay. Thank you.
We do have Mr. Bobby Potter signed up to speak to the bill. If you'd go to the podium, Mr. Bobby, and tell us who you're here representing today, and introduce yourself again.
Yes, sir. Mr. Chairman, members of the committee, I'm Bobby Potter, and I'm here this morning on behalf of the American Council of Life Insurers, which includes virtually all the life insurers in the country, 436 of whom, at least as of last year, were licensed to do business in Georgia. I didn't update those notes. There's several local folks. State Mutual is one up in Rome that had been engaged in this bill last time it was around. So I'll speak in opposition to the bill on behalf of that group. I have had many conversations with Senator Harbin over the last 5 or 6 years. As I look back through my notes, it has gone back to that time, I think, in 2016. I would just say a couple of things. The life insurers are required, pursuant to 332514 now, to check the Social Security Death Master File at least semi-annually. And once doing that, they need to ID the matches, follow up, locate, and contact beneficiaries. They have that obligation in the Georgia Code now. They have had it for some time. The NAIC looked at this issue some years ago, and they, that is all the insurance commissioners in the country, they came up with this thought of the NAIC Policy Locator Service. And that works from the standpoint of a potential beneficiary going upstream and applying into that to see if there is a policy that reflects their name. And if so, that is then pushed out to the insurers. They check that, and then they have the obligation to match that, report to the NAIC, and those reports are on a national basis, not on a state basis. So our insurance commissioner can check the NAIC policy locator from that perspective in that direction and determine whether the insurers in Georgia are checking that. So from our perspective, this is redundant. It's redundant government regulation, and that's the reason that there's been opposition. And the smaller carriers just feel like a quarterly report is unnecessary and expensive and really does no good. So for those reasons, we oppose the bill, Mr. Chairman and members of the committee.
All right, thank you, Mr. Bob. Any questions of Mr. Potter? All right, yes, ma'am.
The way I'm reading the bill, it doesn't require a quarterly report, it requires an annual report. Am I missing something?
I misspoke when I said that. It requires you to check quarterly and do the annual report. The Death Master file and what's in the law right now requires a semi-annual.
All right, Senator Robertson.
Bobby, Mr. Potter, you said that this is redundant and it could be expensive. Explain that to me, if you will. You saying y'all already do this? That did you say y'all are already doing this?
Insurers are already checking the Death Master file twice a year. They're obligated to do that, and that's what they do.
Okay.
I think most insurers, and Senator Harbin indicated that is voluntary in regard to checking the NAIC policy locator service. And I don't know the exact number, but I think most check that. I think they do not check it quarterly. What I'm told is that will be more onerous than they would like to do.
Okay, so you think most of them check it?
I do.
You think most of them check it quarterly, and what this would do would require them to, correct?
It does. It requires them to check quarterly and report annually to the commissioner. That's what this requires them to do.
In your thought, that is such a heavy burden that it supersedes the needs of a beneficiary in order to get, I mean, listen, and I think a couple of years ago when the chairman carried this legislation, if it wasn't for me going through some of my father's paperwork after he passed away, there were 3 insurance policies that my sisters and I were never aware of. Now, obviously, they weren't huge policies, or I wouldn't be in the Georgia State Senate. But they were policies nonetheless that my father had taken his time to take out and to leave my sisters and I, just a little "I love you" after he was gone. But you think this is that big of a burden?
I would not have used the adjective that you used. It's not an enormous burden, but what I'm told by my folks is it is redundant, and it is a burden particularly on small insurers. That's the indication. That's the reason that they oppose it. And those that are going to participate in the NAIC Policy Locator Service, I would say this: the first data from the NAIC Policy Locator Service was very substantial, and they found and collected on behalf of many beneficiaries.
So your testimony is this is redundant, so we're doing this exact same thing already?
No, sir, you're not doing the exact same thing, but the Death Master file is one way to check that deaths have occurred, and that has been required by Georgia law. The NAIC group came forth with this thought of the Policy Locator Service, and they created that. It has been successful. But the state, through this, would now require insurers to look at this and then report it. They think that's redundant.
Okay, thank you.
All right, I think we do have one. Thank you, Mr.
Yes, sir.
Potter. Mr. Carver wants to speak to this bill, or Mr. Padley. If you would introduce yourselves, and we've got a dog bill which always generates a lot of conversation, so we're going to have to. Okay. We're very familiar with this issue, so we're going to have to kind of move on. But wanted to give you the courtesy of speaking. Yes.
Thank
sir.
you, Mr. Chairman. We will be very brief. Yes, you have dealt with this issue before. You passed it unanimously out of this committee and unanimously from the Senate before, and it died over in the House. This is a minimal burden. The truth is that there is still a substantial number of benefits that are not going to the families and beneficiaries in Georgia. And that is a issue because that is resources that people are not getting in Georgia that could be a death benefit, that can take care of funeral expenses, and help those families in need. And those, when these policies were created, the actuarial tables were set up so that they, a benefit would be paid in the end. And so there is still a large unclaimed amount that's out there. This is a reasonable step. As you hear, it's a very minimal step. And the truth is that most every company already complies with this. And so it's a minimal additional burden. Kenneth Pendley from our Georgia NAFA would like to speak for just a second.
I'm just going to speak briefly and give you a quick statistic. And I'll tell you, I've been a licensed insurance agent in the state of Georgia for over 45 years. I started back whenever we went door to door on a debit system collecting premiums. That's how long I've been doing this. One instance I'll give you, it's documented from 3 years ago. Nationwide, and I hope they don't mind me using their name because I use it in speeches giving them praise, they elected on their own to go through their database 3 years ago. It's documented in an AJC article, and they searched their database, and in Georgia, they uncovered 9,577 beneficiaries that they owed $191,783 in unclaimed death benefits. I don't consider Nationwide a large life insurance company compared to some of the others. Obviously, they do a lot of business. But when you think about some of the ones that I think about that it's, quote, a large life insurance company, I only wonder what that number would be. We uncovered a case 3 weeks ago, a lady in Georgia, deceased 3 years ago. Her beneficiaries discovered she had $316,000 in unclaimed death benefit. Those numbers get staggering, and I'm only wondering if this bill passes, and all companies are required to do it because everybody said there are a lot of companies that already do this. Nationwide did it on their own. If all companies did it, what kind of numbers are we talking about? And these are all consumers who are beneficiaries living here in the state of Georgia, clients that lived here in the state of Georgia. And
Yes, we thank you.
Okay.
Well, I'm sorry, we've got to move to the next issue, really, and I think everybody's probably made up their mind on this. So, what's the will of the committee on SB 225 and it's LC 520271. Motion do pass from Senator Robertson. Second from Senator Harbison. Any further discussion? All those in favor, please raise your hand. All right, it passes unanimously. Thank you. Okay. Next, we got a bill late yesterday, or a committee sub late yesterday on a bill that Senator Anderson is going to talk to us about. Senate Bill 142, and it's relating to dog ownership and definition of a dangerous dog and liability for dog bites. So would you like to go to the podium, Mr. Anderson, or, okay, that's fine. Witness mic 2.
Come on.
You got your attorney with you?
Yes, I do. Yes, I do, sir. I'm gonna pass these around.
Ma'am, is your E&O paid up?
Yes, it is.
Okay, I just, a little concerned.
Pretty graphic now. We need to, picture's worth 1,000 words.
All right, Senator Anderson, introduce your colleague, please.
I'm gonna let her introduce
Okay.
herself.
Good morning. I'm Claudine Wilkins.
attorney.
attorney at law.
Clay, all right, spell that for us, please.
CLAUDINEWILKINS.
All right, thank you. And it do you have a firm name?
Wilkins Law.
Okay, we have to get it in the record. Thank you.
Thank you, Mr. Chairman. Committee members, I want to start off by saying this. I'm a dog lover. I love dogs. I've always had dogs. I will always have dogs. All this bill is about is if you want to own a dangerous, vicious dog, you got to take responsibility of that dog. That's basically what this bill's about. This is a nonpartisan bill. I had 36 co-signers on the bill out of the Senate. This bill is brought to you because of a lot of victims, but the one that's near to me was in my neighborhood. Happened at Christmas. 2 young boys got bicycles for Christmas. They was riding their bicycle down public drive road in the subdivision, and 3 dogs attacked them. The grandmother had to take the child's bicycle and beat the dog off of the child. The child is at AU Child's Hospital in Augusta right now, fighting for his life. The child has no scalp left. They're trying to figure out what they're going to do there. But we got more than just him, and I want to name this the Justin bill after him. But another reason why I'm here is that the parents had to start a GoFundMe funds to raise money to help with the medical bills. And the community's been very gracious. The last time I heard that they done raised over $250,000. But this goes back to what I was saying at the very beginning. This is a bill to make sure that if you own, and I'm not saying you cannot own one, but if you own a dangerous, vicious dog, then you got to be responsible. We've just had lately in Texas, last week, elderly man got killed and was attacked by a dog. I got here in Georgia, a deer hunter was going into the woods to just take down his stand and got attacked by 3 dogs. Let me go on and say this before we go even further. Now, this does not pertain to anybody that's hunting with dogs. So the agriculture and the hunting of the dogs is still intact. It does not touch that area of the bill. The man that was in Texas that got killed, even the fireman that came to help got bit by the dog. But this bill requires the dangerous, vicious dog owners to have it microchipped. It requires sterilization. It requires, on a dangerous dog, $50,000 insurance, and on a vicious dog, $100,000. It declares who enforces the law. We have roughly 27 counties in the state that does not have an animal control. So this bill allows the sheriff department or any other law enforcement to be able to carry out the duties such as city police. It does not allow, if a county or city wants to even have a stricter rules, they still have that power. You want to say, well, Senator, what's the difference between a dangerous and a vicious dog? I didn't know it until my attorney here explained to me. But, if I say this wrong, you correct me. But a dangerous dog is a dog that just gives a puncture wound, and it basically does not need stitches, no more than 2 stitches, right?
Just a puncture wound,
Puncture wound.
1 stitch.
Ma'am, would you pull that mic over to you, please? And Lee, pull yours more in front of you.
Yes, sir.
In that way.
And then also, but a dangerous dog is a dog that really does severe damage and had to have
Vicious.
a vicious dog has to do where you have a dog that's really done a severe amount of damage, and the human being has got to have several stitches. So that's the difference between them. But I'll stop right there, and if you, we, like I say, we got 36 co-signers, and it's a nonpartisan bill, and I think it's a way that we can improve the law that we already have.
Yes, sir, I was thinking you might. Senator Cowser, I'll go with you first.
Thank you, Mr. Chairman. I was a co-signer, but this is a different bill than the one I co-signed. I was signing one that simply required insurance on the part of owners of dangerous or vicious animals. My questions concern the very first page 2 here, where you're changing the definition of a dangerous dog. Current law, I'm down on line 37, page 2, front page. Current law specifically holds that just barking, growling, or showing of the teeth of a dog shall not be sufficient to classify it as dangerous. You're striking through that, which leads me to believe that now, under your new law, if you got a dog that barks or growls, even if they're not biting anybody or attacking anybody, they can be called dangerous. And then later, when you define vicious, if they do that conduct more than once, they've moved up from a dangerous dog to a vicious dog just for barking twice, basically, or growling. That concerns me that you're removing that. I assume that's on purpose to take out this exclusion for growling or barking or showing your teeth.
Senator, we met with several different groups, and this was one group that asked that the barking be taken out. I'm gonna let my lawyer.
One additional word was added on 35, an unjustified threat. So naturally, dogs bark and growl and snarl as a way to communicate that they're not happy with whatever is in front of them. But the issue is the unjustified threat is key, and unjustified or justified is actually defined in the law. So the act that the person perceives has to be something unjustified. So if it's barking plus running after you, or snarling and coming after you, or making that extra step to come after you, that creates the unjustified threat.
Okay. Thank you.
Senator Harbison.
Thank you, Mr. Chairman. And Senator, I just want to commend you for bringing this bill forth. It's a real problem anywhere. Right. In Talbot County, I had an elderly woman, 70-year-old Nellie Raylant, I believe her last name was. She was hospitalized here in Grady Hospital for several months. And she was really, she was almost killed. She had a dog herself. Pit bull attacked her while she was walking on a street, unprovoked, just walking up the street. And they came, and she was rescued. Fortunately, about a hunter just happened to walk by and saved her life. But she was going to be killed. So I just want anything you can do to, help that situation of unprovoked dog attacks like that. I just would be very supportive of that, with everything being equal. And I'm not a dog hater. Matter of fact, I'm a grand dog owner, so I have a grand dog, and he sort of owns the house when he's around. So
I have one too.
yeah, but I just want to let you know that it's a real problem in a lot of areas. So I just want to commend you for that. Thank you.
You had to buy the dog food for the grand dog.
Yes, sir. Big time. A special brand.
Yeah.
I think you had one, right?
I had one question I wanted to ask
Okay.
as far as, thank you, Mr. Chairman. I noticed on page 2, line 39, it says while off,
Working on.
hello, are we there? Okay. While off the premises, one of the things I see, in fact, I've got a situation where I see a dog come onto the property of another person, and is aggressive on that property towards someone. Does this bill in any place address the rights of that person to really deal with that dog in any fashion?
100%.
And when I say that to you, I walked on the person's premise. He came on my premises. He came out towards me. The owner was 150 yards off, and he kept coming towards me, and I was ready to deal with the dog in a different manner. My question is there immunity for anyone who's defending themselves in this bill? From a standpoint, I know with a lot of animal lovers, and I love animals all my life, but yet there are some that are aggressive. Is there immunity for anyone who would, I'm going to call it, defend themselves, if on their premise especially? Is that addressed anywhere in this bill? I was looking for it.
It is addressed in the animal cruelty laws, absolutely, 100%. You have the right to kill, shoot, whatever you got to do to protect yourself or person or your own property. That includes your own dog. So yes, you have that immunity. And if you look on lines 84 through 91, there are some exemptions placed right here, that no dog that's being used for law enforcement or military purposes as well, or anyone that's committing a trespass or abusing or committing or attempting to commit any violations under this chapter. So that protects you if you've got a tortfeasor or a trespasser on your land. They're not going to deem your dog dangerous. If you have a threat coming to you, you have the right to protect yourself. That is not at all affected by this bill. It is stated in another law, though.
Okay. I see that as one of the things where dogs go off premise, especially they're on somebody else's premises from that standpoint. Okay, thank you. Appreciate it.
I've lost the count here, so. Okay. All right, so Senator Merritt.
Thank you, Senator, for bringing this bill forward. I, too, am a dog owner. I have 2 rescues that I absolutely love, and they're stinkers, but I love them. So I share your love for dogs, but I also am troubled by irresponsible dog owners as well. And it is annoying when people have their dogs off leashes, they don't have them contained and things like that. But I just want to make sure that we aren't applying things too broadly, and I'm looking at the bill and I understand that the determination of a dangerous dog is going to be by a professional. I want to get that clear. And has anyone from a veterinary professional evaluated anything that we have here?
We did that last year, yes.
Okay.
And veterinarians do not want to get involved in determining whether a dog is dangerous, because there's a lot of reasons. One, they get involved in the case. That means they become either an expert or they have to be subpoenaed. When the dog attacks, it's the totality of that circumstance. So by the time the veterinarian gets it, the dog could be wagging his tail and licking the vet's hand. So it's extremely difficult to evaluate the propensity of aggression after the fact and brought into a vet. Vets don't typically like to be called to court or subpoenaed, and they're afraid that if they wrongly identify a dog as dangerous, they're going to be sued. Or there's so many other problems with that scenario. So the Georgia law states right now as a mandate that every county has to have a rabies control officer and a dog control officer under 2 separate parts of our law. Many commissioners I speak to, when you just did a training in Blue Ridge, do not know that. They have no idea that they're supposed to designate. So the goal is to designate someone who's familiar. And if you look at the rabies law, it says to choose someone familiar with animals. And, you know, the public health department is the one that records the actual bites.
Okay.
Because that has to be reported. There's got to be a rabies protocol, et cetera. So to bring vets into this, to be the evaluators, is just not feasible.
Okay, but, and if I can, Mr. Chairman, so the evaluator, the primary evaluator would be someone from the counties who they have determined as a
Designated.
professional that is designated, and
Right.
they will make,
The determination.
They will make the determination, but they're making the determination based on an incident that has happened in a totality of a body of offenses here, and
Correct.
there is physical evidence that this dog has done something.
And the dog owner always has a right to a hearing. There's
Okay.
due process within this bill.
Okay, thank you.
All right. So who's Senator Kirkpatrick,
She answered my question.
and then Senator Robertson.
First of all, Mr. Chairman, I appreciate the handout brought back, you know, some tough feelings. I met the father of that child last year on this same legislation. But I don't own any dogs. My wife and daughter own two that live in my house. But my wife has a dachshund who is old. His hair's almost the color of mine. And if somebody with a bright and sunny disposition comes into my house, say a Senator Calzert, and reaches down to pet that dog, there's a chance that that dog nips him, just because dogs read personalities. Would my wife's dachshund then be classified as a dangerous dog if there's a puncture wound on the senator's hand?
Do you want me to answer that? It depends, as every lawyer will tell you. So if you have the superior knowledge that your dog is testy or irritable, and you fail to warn that person, and the person's doing something completely natural in your house, like walking past to the kitchen or whatever, and the dog just bites him unprovoked, yes, you could be liable. But if you say to him, my dog is testy, you don't want to get near him, don't try to pet him, or whatever it is, don't even get near him, then here's your warning, then he takes the assumption of that risk, and you are no longer negligent because you gave him a warning.
Okay, change the scenario a little bit. What if I don't know my dog is testy? I don't know my dog's having a bad day, and somebody reaches down to pet my dog and it bites him.
Under the dangerous dog law, if there's a puncture wound on him, that's a dangerous dog. That is correct. In the civil side, you have to carelessly manage that dog.
So would I have to take that dog and have it chipped, sterilized, and I guess registered?
Yes.
Okay.
All right, so anybody else have questions? I have some, if you don't mind. And I certainly really appreciate the intent behind this. I do think dog bite legislation's been on the books a long, long time, and a lot of case law surrounding it, and I think we need to be cautious moving forward, especially with something most of us have just seen this morning. I agree with Senator Calzert that lines 36 through 38 are sure. I don't understand striking that language.
Mr. Chairman, I'm flexible. If y'all want to put it back in, we can put it back in.
Mr. Chairman,
Let me finish my line of question, and then we'll have more discussion if you don't mind. I don't like line 39. You're adding or injured or injures a pet animal without justification. What if, I can see a scenario where dogs are, playing roughly, because dogs like to do that. And one dog injures really unintentionally and thinking I know they're not human beings. I don't know. But anyway, accidentally injures the other animal, then that triggers them to be a dangerous dog. And if they do that twice, they become a vicious dog. I just think that's a little bit much. And then the other thing is on line 90 and 91, looking at this from an insurance perspective, because that's what I do for a profession. I'm not an attorney. No dog shall be classified as a dangerous dog or vicious dog based on breed or perceived breed. Well, the insurance industry, that's the practice. The insurance industry uses breed to underwrite policies. And my question is this going to prevent the insurance companies from asking what kind of breed of dog do you have? And if you have a pit bull or some sort of breed, then we're not going to insure you, or either we're going to put a exclusion for your dog on the policy, and that concerns me. So those are, and that's just kind of a quick perusing the bill. And again, not being an attorney, this is a very legalistic issue. I'm not sure that this wouldn't have been better served in judiciary, really, but here we are. So now, do you all want to respond to any of that, or?
Let my
Yes, sir.
attorney address your issue.
Just to respond to your line 39 and 40, the original bill back in 2012, when Dr. Maddox in the House presented this, did have the word "or injures a pet animal" without justification should assuage your fears about whether the animal was playing or aggressively trying to harm the animal. Just last week, for example, in Forsyth County, a neighbor's dog came into the neighbor's backyard and attacked their dog without any provocation. The owner came over with an axe and started axing the victim dog in front of the owner. He was charged with animal cruelty, but the dog has now $10,000 worth of vet bills. So it can be adjusted, this line, to address your concern about, first of all, we have while off the owner's property. So the attacking dog is off the owner's property, period. Has to be that scenario. When you kill an animal, there's maybe cremation, maybe $100 worth of bills. When you have an injured pet, it's more expensive. The term "without justification" was to deal with the situation if the dog wanders off property. First of all, it's at large or not under the control of the owner. We can certainly amend here to assuage your fears and really hone in on what we're talking about, which is a dog off property that just wanders the streets and starts attacking pets, which we get those calls almost weekly. And then as far as
Can I?
Yeah.
So your scenario is one thing.
Right.
But we have, especially in metro areas, but even in smaller communities, we have dog parks. We have restaurants, I think, even maybe that allow dogs. I mean, so just off the owner's property doesn't mean like they're trespassing on somebody's property. I mean, these are organized areas for dogs to be gathered. And to say whether a dog was justified or not, I mean, what if the injured dog, insulted the other dog? I mean, I don't know how you're going to, that's just.
we certainly are.
I mean, that's just very subjective. That bothers me.
Yeah. And then it's certainly offer an amendment. I'm sure the senator.
Like I say, Mr. Chairman, we flexible there.
And then on 90 and 91, this was offered by an outside group recently, and it's up to the senator to decide what he wants to do with line 90 and 91, but that was not something in the original bill. It was simply offered by an outside group recently.
Right.
Well, I just don't want that to somehow unintentionally adversely impact the ability of insurance companies that are writing homeowners insurance to use that as a criteria. And maybe it doesn't, but does anybody have an opinion about that? That's a lawyer on the committee or anything?
I'm having a hard time absorbing it and thinking how to change it on the fly to get it right, but so I hate to say without having more time to really kind of dig in, and I think I'm worried about another meeting I got to go to, so I'm
Okay.
getting distracted.
And it's past 9, I'm sorry. Senator Merritt had
I waive. I would move table.
a motion to table. Have a second?
I'd second that under the not time in this meeting, time in this session.
I have a motion and a second. Any discussion on the motion? All those in favor of tabling the bill? All right, it's unanimous. Let's see if we can figure something out, Mr.
All right.
Chairman. And thank y'all for
Thank you so
presenting
much.
today. Yes, sir. All right, that's all we have, and we got other meetings to get to. Thank y'all for staying, and the meeting is adjourned.